Thank you, Mr. Chairman. I appreciate that. And Director, thanks. It's good to see you. I feel like we see each other quite often at events lately. It's good to see you, though. And thanks for testifying. This is an important part. This is really, frankly, of all the things that we do in this committee, is one of those areas that I believe we find some of our common agreement and our greatest gains if we just simply put our mind to it and say, how can this affect? This is also probably, although it is much less publicized as many of the other things in our committee that we do and doesn't get the press that it deserves, this is the thing that actually drives and focuses our economy in ways that many of us in this room could never imagine and have been talking about for years, because I believe the very things that your office deals with and the very things that our patent and trademark office continues to work with really determines where we're going to be in the coming years, whether it be in technologies that already exist or the technologies that we couldn't even think of at this point. So again, I just want to think about that. And when we celebrated World IP Day, I think it all just emphasized, really those things that we all can come in agreement on. I'm hopeful, Mr. Chairman, as we work through these things, this will be something that we focus on a great deal in the future. However, just like the chairman, there are some things that I think we're discussing and want to continue to talk about, and that's making sure that the patent litigation abuse problem is something we continue to look at, but also make sure that it is fair not only to all patent holders, small, medium, and large, but also make sure that there's an easier system in which there's not just a constant, what I'll call circle of litigation, circle of problems, in which there's never a surety of that content or that patent owner actually having something to be valuable. One of the areas that I do want to talk about, and I know we'll talk about today, is the patent eligibility issue, and of course that is the 101 discussion. Supreme Court has basically put us through, Director, as you well know, a tortured exercise and called on the courts and Congress to fix it. The way they've come about it, especially with the opinions of the U.S. Court of Appeals on the Federal Circuit, the highest patent court in the land, and next to the Supreme Court, in which at least 5 of the expert judges there complained that the test is flawed and must be replaced, okay? We cannot sit back and continue to watch our mighty patent system, a key driver of this innovation, continue its slide. That's why myself and several colleagues in the House and Senate, including my friend Chairman Johnson and numerous stakeholders, have been investigating to develop a patent eligibility test that works for all. Another area of the patent system that requires our attention is the USPTO's implementation of the inter-party or IPR proceedings. It's been 8 years since we established those proceedings, and they've both been heralded and vilified all at the same time. I know that's not surprising to anybody from this committee. But many are happy to avoid the costly patent dispute in a federal court instead of rely on the PTAB to quickly and less expensively invalidate an accuser's patent. But others argue that the PTO has implemented countless rules skewed against patent owners that result in good patents being struck down in bad IPR decisions. I have heard numerous reports that defendants in litigation are filing multiple similar attacks on the same patent or are using surrogates to skirt prohibitions to repeat attacks. I've also learned that since in instances where small businesses sought to assert their patents in federal court to stop the theft of their valuable IP, those thieves instead are forced to defend themselves. From those thieves, they're forced to defend themselves and their patents before a PTAB, which issued a questionable decision invalidating the patents. Fortunately, some of these small innovative companies could afford to appeal the PTAB's flawed decision and have their patents restored by the federal circuit. But this demonstrates the PTAB proceedings may be used by well-funded companies to harass small businesses in submission. The cost for appealing a bad PTAB decision may be too much for small businesses to bear, resulting in their loss of their patents, their innovations, their business, and at the hands of an unscrupulous copycat. Again, very thing that we're trying to avoid, we're actually seemingly incentivizing, and that's something that we need to look at. In this hearing, I want to hear about these concerns. I want to know about the patent eligibility test and how we should craft it to promote investment in important technology industries while avoiding a resurgence of patent litigation abuse. No one wants to go back there. But we also can't have a system that incentivizes an incessant going back and forth, or what I'll just call a circular, never being sure is my patent worth what my patent is supposed to be worth. If we ever lose that in this country, if we ever get to the point to where our patents and our copyrights, our trademarks, the very thing that really has based our intellectual property exercise on for well over 200 years, if we get to that point to where that doesn't matter, then we will go backwards economically, we will go backwards in the world, and we will have our brain drain is what I will call it, that hope drain will go other places where it is protected. The reason we have the greatest economic system, especially involved in IP and all of these other decision makers, is we protect our IP. strong intellectual property protection is not a hindrance. It is the very catalyst to growth. It is the very catalyst to our economic engines. And with that, I look forward to this hearing. I thank you for being here. It is always a pleasure to see you. And I appreciate the work that you've been doing in this area of, to find a solution and to not just simply wait and say, well, whatever Congress does, I'll work. You've been able to take some of that initiative. That's a good thing to see, because I think you've been taking all the players into that role as we go forward. With that, Mr. Chairman, again, thanks for calling us here. And this is, again, a good time for this committee, and I appreciate you calling. And I yield back.